Yeah, this same thing here. I have it calendared, but no link. I had to get someone to help me too.
Oh, geez. December of 2025. Oh, looks like we're about ready.
Good afternoon. Can you hear me?
Yes, Your Honor.
Yes, Your Honor.
Good afternoon. This is CV 2024-012707 in the matter of Andrew Johnson versus Steve Palestino and Jill Palestino. This is the time set for a trial management conference. Can I have counsels please announce for the record, starting with counsel for plaintiff?
Good afternoon, Your Honor. Robert Connolly on behalf of plaintiff Andrew Johnson as trustee of the Andrew M. Johnson Trust.
Thank you.
Wade Cause, Your Honor, on behalf of defendants Palestino.
All right. All right. When I joined the meeting, it sounded like there was some concern that something had been miscalendared. Was that for this matter?
I was having a hard time finding the link for this conference. Is why. So it was calendared, but the link wasn't on it. And so Rob forwarded it to me again, and I was trying to figure out why I didn't have it in there. So just an internal matter, Your Honor. Thank you.
Oh, okay. I wanted to make sure it wasn't something that had been missing from the minute entry setting this hearing or something to that effect. All right. Well, let me start with, I guess, the bad news. The bad news is that you are double booked and you are the newer trial in this case. So, we're still a month out-ish. So the other trial could still settle. I haven't had the trial management conference for the other trial yet. I'll have it next Monday. So I'll get a good sense from them about where things are going. But I wanted to tell you that up front. I can put you on case transfer or maybe the other case will settle and we can still go forward with our anticipated trial date. Any, I guess, questions about that?
No, Your Honor, but as for plaintiff, we'd like to stay with you, so we would have no problem to a small bumping of the trial if need be, but we'll wait to hear from the court on that.
Yeah.
All right.
We also have some news for the court, which may potentially slightly impact scheduling, which is, I think the parties have agreed to a bench trial, which might reduce 1 day of our 4-day allotment.
Yeah, and actually, Your Honor, I think if we do the bench trial based on the list of witnesses and we're eliminating jury selection, etc., I'm not, based on the length of time of the estimates for the witnesses so far, I don't see this thing going over 2 days at all. Maybe day and a half.
That could be as well, yeah.
Okay. Well, that answers the first question I was going to ask, which was whether the amount of days that we have set is still accurate. So I'll put in here a note that parties agree to a bench trial of 2, possibly 3 days. Okay. Well, then I think that will eliminate a lot of the discussion that we need to have today regarding trial management. We won't have to worry about jury selection. So our trial schedule will be 9 a.m. to noon, 1:30 to 4:30. We will take breaks in the mid-morning and the mid-afternoon for 15 minutes at about 10:45 and 3 o'clock. That being said, if you're in your examination and you feel that there's a natural stopping point that's good to break, feel free to let me know and we can take a break at that time. We'll break for lunch between noon and 1:30. We may need to start later or end later, but I anticipate that that'll probably be less of an issue given that we won't have a jury. I'll allocate 50 minutes for a bench trial. I'll allocate 50 minutes of every hour for trial time. So that'll give us, see, we have 1, 2, 3, 4, 5, 6. 6 times 50 minutes. Is that 300 minutes per side? If we do 2 days.
Yeah.
And I'll keep track of time on a time tracker I have, and give you reminders whenever we break of how much time is remaining. If I forget to ask, or if I forget to give you a reminder, feel free to ask me for a time check and I'll happily provide that. No jurors, so we don't need to talk about juror selection. We have, this is a damages, is the natures of the claims remaining to be tried. And then you have a stipulated case summary that you provided to the court. It's the list of witnesses in the pretrial statement still accurate?
It is from plaintiff, Your Honor.
Hang on just a second, Your Honor. I apologize. I think it is. I just haven't.
For a defendant in the pretrial statement, all it has is Mr. Palestino.
Yeah.
Okay.
That is true on the defense side. Yes.
Do we have any special witness situations such as a need for an interpreter, remote witnesses, anything to that effect, Mr. Connolly?
I don't believe so, Your Honor, no.
Mr. Cos?
Not that I'm aware of, Your Honor.
All right. The pretrial order had set a deadline for exhibits. I'll affirm that deadline. If you've used Case Center before, then you'll know that it marks exhibits as plaintiffs 1, defendants 1, plaintiffs 2, defendants 2, and so on. You're not required to use Case Center in displaying your exhibits at trial. You're free to use any other program that you would like. I'll be looking at the exhibits on Case Center, so if you do decide to use a different program, just make sure that your numbering is identical to the numbering in Case Center. And if you would like that numbering, you can request a copy of the clerk's official exhibit list with the numbering on it, and we'll be happy to give that to you. The court will rule on objections to exhibits during trial. Admissions of exhibits, whether through stipulation or through lack of preserving an objection in the pretrial statement, will be addressed during trial. If you plan to use exhibits during your opening statement, please provide the exhibits and the opening statement to the other side 24 hours in advance so they can make any objections that they'd like. And what I mean by that is if you're using a slideshow during your opening statement, something to that effect. Will either party be requesting a court reporter, Mr. Connolly?
I don't believe so. I believe the sort of in-house video and audio should suffice.
Okay. Mr. Cos?
Agreed.
Okay. All right. Going over courtroom protocol. Please state the basis for your objection, such as hearsay or relevance, or by rule